A251. I will be presenting the case of Jalani bin Muhammad and another against Shahrul bin Abdullah and another, a land dispute case that explored the principles of specific performance. Let's begin with the facts. The land originally belonged to the Zul binti Idris, who in 2004 agreed to sell it to the second plaintiff. A deposit was paid, but the transfer never took place before her passing. After Zul's death, the land was transmitted to the first defendant, who became the administrators of her estate. Years later, in 2016, the first plaintiff entered into a new sale and purchase agreement with the first defendant for 94,000 ringgit, paid a deposit, and even lodged a caveat to protect his interests. But the story didn't end there. Later that same year, the first defendant sold the same land again, this time to the second defendant, for 102,000 ringgit. The land was then transferred to the second defendant's name. The plaintiff was shocked and challenged this transfer, claiming the full purchase price was never paid and that there was a fraudulent conspiracy between the defendants. The defendants argued otherwise, saying the sale was genuine, valid and properly documented. Both the High Court and the Court of Appeal dismissed the plaintiff's claims, holding that the transfer to the second defendant was valid.
In this case, there were 5 main issues. First, whether the second respondent was a bona fide purchaser who paid the purchase consideration. Second, whether a material witness (MYC) was not called. Third, whether the transfer instrument was void or insufficient under Section 340, subsection 2, Clause B of the National Land Court. Fourth, whether the first appellant was entitled to specific performance. And fifth, whether the High Court was faultless when ordering a refund of the deposit.
For the first contention, the second respondent said he paid the full 102,000 ringgit in cash to the first defendant. He believed this made him a bona fide purchaser, meaning he bought the land honestly and should have indefensibility title under Section 340, Clause 3 of the National Land Court. He even had acknowledgement letter to prove it. But the law under Section 340, Clause 2, Clause B of the NLC say if the transfer instrument is void or insufficient, like when the payment isn't properly proven, then the title can be defeasible. And according to the case of Supramaniam against Jimmy, payment has to be proven with real evidence, like check, receipt, or pen slip, not just someone's words. So what did the court say? The court found there was no independent proof that the 102,000 ringgit was ever paid. No receipt, no check, nothing. Because of that, the transfer was invalid and the title became defeasible. In short, the second respondent was not bona fide purchaser because saying I paid cash isn't good enough without proof.
Regarding Section 340, subsection 2b, the law states that a transfer instrument is void or insufficient if the consideration is falsely declared or not properly paid. Here, the payment was not sufficiently evidenced with receipts or bank statements, so the transfer was deemed insufficient, making the second respondent's title divisible. On specific performance, court grant it when the contract is valid. However, because the transfer was obtained via an insufficient instrument and consideration was not proven, the court held that specific performance could not be granted.
Finally, the plaintiff sought specific performance, asking the court to compel the defendants to complete the sale in their favor. But the court reiterated an important principle: specific performance is a discretionary remedy. It is not granted automatically, even when the subject matter is land, which is considered unique. The court held that before specific performance can be granted, the plaintiff must prove that all contractual and legal requirements have been fulfilled, especially payments of the purchase price. Since the plaintiff failed to prove full considerations, the transfer instrument was invalid, and the title was divisible under Section 340, Clause 2b. Therefore, specific performance could not be ordered.
The next case is between Jiowin and CC Land Resources. This case is an appeal from the High Court concerning the specific performance of a letter of undertaking LOU related to a joint venture development project between GeoWing and CC Land Resources. Initially, GeoWing and CC Land Resources entered into a joint venture to develop shop houses. GeoWing owned the shop houses and promised through the LOU to transfer one free unit to a nominee of CC Land Resources upon the completion of the development. After the development, 11 units met the agreed size, but 3 units were slightly smaller. CC Land Resources requested the transfer of the free unit as promised, but GeoWing refused, arguing that the LOU was invalid and the units did not meet required specifications. The High Court ordered GeoWing to comply with the LOU. On appeal, GeoWing challenged the decision, raising 4 main issues. First, whether the LOU breached Section 221 of the Companies Act 2016 concerning the interest not declared to the board. The court found that this claim was an afterthought and irrelevant because GeoWing as an outsider could not rely on this. Even if there was a breach, the law made the contract voidable only by CC Land Resources, who choose to enforce it. Second, GeoWing argued that the LOU contravened Section 223 of the State Companies Act 2016, which restricts disposal of company property without the board approval. The court clarified that the LOU was not a disposal originating from CC Land Resources, but a mere relinquishment by GeoWing. So, Section 223 did not apply in the present case before us. The joint venture agreement, not the LOU, was the agreement that will affect property disposal. Third, GeoWing contended that the development did not comply with the specifications due to some units being smaller than required. The court applied the principle of business common sense, holding that the slight size differences were insignificant and did not justify nullifying the LOU. The court emphasized a flexible interpretation so the respondent's interest would not be unfairly held hostage by minor deviations. Fourth, GeoWing claimed forgery in the board resolutions approving the LOU. The court rejected this claim, finding that the evidence did not support forgery and that the complaining witness was unreliable due to bias and debt to GeoWing. Ultimately, the appeal was dismissed. GeoWing was ordered to honor the LOU and transfer the free unit and to pay 30,000 ringgit Malaysia to each respondent. This
The next case would be Genting Highlands against GM Aero Support. This case involved a dispute between Genting Highlands and GM Aero Support Sdn Bhd. It is regarding to the unauthorized works, excavations, piling, slot making, and also construction works that carried out by the defendants on the land of the plaintiff. The defendants' work allegedly caused damage to the plaintiff's private road and also posed the safety risk to properties including the First World Hotel. Plaintiff sought injunction to restrain and mandate the defendant to stabilize the slopes and halt unauthorized works. The EOT was applied by the defendant. Defendant also applied to recuse the court-appointed geotechnical expert named Dr. A. Tech On, which they alleged the biasness and misconduct from him. There are 3 main issues that we can construct in this case. Number 1, whether the defendants were entitled to an extension of time to complete the slope stabilizations work. Number 2, whether the plaintiffs were entitled to a restraining injunction and a mandatory injunction. Number 3, whether the court-appointed expert should be removed for alleged biasness and misconduct. These are the plaintiff and defendant's contention. Number 1, EOT applications by the defendant. Defendants sought extension of time citing that COVID-19 related movement control order and government restrictions affecting their work progress. They argued that the efforts obtained to necessary permits to carry out the critical slope stabilization works were delayed due to the pandemic and regulatory controls. What does the court say? The court held that the burden of proof was on the defendants to make full, frank and candid disclosure for EOT. Defendant failed to satisfactorily explain the delay omitted slope stabilization from works schedule and did not commence works promptly before the MCO. The court dismissed the EOT application. Contention number 2 coming from the plaintiff. Plaintiff argued that there was a bona fide serious issue concerning the unauthorized work affecting the planning permission, slope stability, and danger to properties and public safety. So, they claim damages that would be inadequate given the potential for landslide and loss of support. The court said that agreed with the plaintiff, holding serious questions to be tried regarding the planning approvals and the slope safety. The court found a real risk of slope failure to demonstrate by a prior landslide incident that happened before. The balance of convenience favored restraint on the defendant's activity to prevent the irreparable harm and damage were inadequate. The court granted both restraining injunctions and mandatory injunctions. Contention number 3 coming from the defendant. Defendant alleged the court expert violated professional engineering rules. Dr. Oi Tak Un was unfamiliar with the approval process, imposed excessive fees, acted unfairly, and was biased towards them. Thus, the necessary of recuse is a must. The court found that there are no material proof stating that the allegations of breach and biasness. The expert's role of being the real danger of bias thus did not apply by an expert. Defendant had delayed raising the bias concerns and had previously accepted the expert fees. The recusal application was dismissed with the cause. The court have 4 held to be announced. Number 1, defendant extension of time was dismissed. Number 2, the plaintiff injunctions were allowed. Number 3, the court expert recusal application was dismissed. And the last one, costs were awarded again to defendant.
Question, did he take it in my place? Question, clean it up like a crime scene. Question, did you like when he came in? Speed it up like you're a racing. Question, make a mark like a suntan. Question, call you up like a new
7. So now we will move on to the last case for the injunction, which is the case of Tengku Reza Shah and Bansa Heights Pavilion, where in this case, the plaintiff was the majority shareholder for the Bermasi Holdings, a company that originally owned 4 lots of land, and 2 lots were transferred to another company, while another 2, which is the lots of 6894 and 2960, were later sold by the Bermasi's former liquidator and eventually transferred to the defendant for the project of development. Believing that the transfer were improper, the plaintiff filed for the suit of 258 challenging their validity. The High Court agreed with him and found there was a fraud and misconduct in how the land was transferred. The court awarded him damages but did not return the land, so he appealed to the Court of Appeal. While waiting for the appeal, the plaintiff applied for the Mariba injunction under the order of 29 Rules 1 and 2 of the Rules of Court 2019, where the injunction stopped the defendant from developing the land, selling or advertising the unit, accepting deposits, charging or mortgaging the land, and paying 90% of the project's value to another company. Then, the defendant applied for set aside the injunctions. In this case, there are 4 issues. The first one is whether the plaintiff has a good arguable case against the defendant. The second one is whether the plaintiff should file an application for the Mariba injunction in the Court of Appeal. The third one is whether the plaintiff had a locus standi to commence action against the defendant. And the last one is whether there was a risk that the assets will be dissipated. Next, for the application, the first contention is that the plaintiff had a good arguable case to remain the injunction, where this has been shown in the High Court under the suit of 258, where the High Court had already confirmed there was a fraud in the transfer due to the former liquidator's misconduct. This can also be seen in the case of Lee Kai Uen and another, where it was held that there was a good arguable case, means that the claim is more than just a possibility and can be seriously argued. The court also applied the 3 main requirements for Mariba injunction. The first one is the good arguable case, the second one is the respondent has assets in the jurisdiction, and the last one is there is a risk of a real dissipation. Move on to the second contention, where the application for the Mariba injunction is within the jurisdiction of the High Court. The defendant argued that the plaintiff should have applied to the Court of Appeal, but the law is clear, which provides that the High Court also has the power to grant a Mariba injunction. This can be seen in the case of S&F International and Transcon, where the Federal Court held that the High Court judge and not the Appellate Court can also handle interlocutory injunctions. And the Court of Appeal can only review whether the High Court made a legal or there was a factual error in the decision. So the injunction was properly brought before the High Court. So next, we will move on to the third contention, which is that the plaintiff had a locus standi to commence action against the defendant. So the defendant questioned the plaintiff's right to sue because he was an undischarged bankrupt. However, the plaintiff had already obtained the liquidator's sanction and approval from the insolvency department. This can also be seen in the case of Lai King Lu and Merais, where once a company is wound up, the liquidator controls legal proceeding with proper approval. The plaintiff did have locus standi. Lastly, there is the real risk that the asset will be dissipated by the defendant. So, in this case, there was a strong evidence that the defendant might dispose of the land before the appeal ended, where the defendant was actively developing the land, advertising online, distributing the brochures, and operating a sales office, and also collecting the deposit, including the 10,000 ringgit for a unit price of 714,000 ringgit.
So this shows that there was a real and immediate risk for the dissipations of the assets where the court can grant for the marital injunction. So in this case, the court held that on behalf of the plaintiff to retain the marital injunction since all the requirements were met and to set aside the defendant's application with cause.
Question, did he take you to my place? Question, clean it up like a crime scene. Question, did you like when